Okay, abusia yabema kwaba sonkoso ereba POG Media so. Yadembe ko political highway ne so highway ne de ensem bebi so a yenso ya age pene se bem ya bedwafo no ahu de eko ene de eba. Abusia den na eko so ewo political highway ne so. Ayesa so Tsikata. Wabaremu ewo Supreme Court e de ensem bi aba betudwa. Ensema odi betuja na busia yebe mama makọ na makọ akoti ensema ekoso Chief Justice Torkoono ene afenyoma akins nioma omo ye editia eye Speaker of Parliament aban backben no abusia ene Parliament tenas na sasu Tsikata epiem wo behwe wonde sa papa na ye mom yenko na yenko nkoti ansa na ebekọ no o ensem kan bi afahye your comment section mu like na share ma afofo nso ensa into me and Kabi, Madam Ase.
On to talk about the image of the judiciary. But Mr. Tsikata was going to make an example of how these things affect the image of the court.
Well, not so much how they affect the image of the court, but in a way how certain decisions of the courts which are not compliant with constitutional principles, constitutional provisions, in the end sort of backfire, and in a way, the court itself does get discredited. So I'll give you the example of what happened in relation to the Honorable Member of Parliament for Aston North. In that situation, Akuffo's case, where again, there was a High Court election petition, and the Supreme Court had said the High Court is where election petitions should be adjudicated and so on. The High Court had decided the matter was on appeal. That process was going on. Then the petitioner runs to the Supreme Court and says that they want interpretation and enforcement. And somehow in that situation, unlike all the other precedents, the Supreme Court takes up jurisdiction. In fact, I'll tell you, the Supreme Court, even before it fully went into that case, they had before it, I think Mr. Frank Davis, a lawyer for the petitioner, went before the Supreme Court with an Exp0sě application similar to what Afenyo did. In that case, the Supreme Court said, no, we can't proceed without giving a hearing to that Member of Parliament. So the Supreme Court actually did not proceed Exp0sě. They went on notice, and then in the end, they decided against Honorable Exp0sě, on grounds which we don't need to get into at this stage. But it was not really a decision in compliance with the Supreme, the Constitution and the Supreme Court's own precedents. So based on that, an election had to be held. A by-election had to be held in that constituency. And guess what? Honorable Exp0sě won by an even greater majority in that. Again, the Supreme Court's earlier interim injunction, the interlocutory injunction that they gave, was clearly related to attempts to pass the e-levy. Because with Honorable Exp0sě in Parliament, the government was having difficulty in getting the numbers to pass the e-levy. So an injunction is obtained against him in the Supreme Court. He can't vote. E-levy is passed. What has come of the e-levy? The e-levy is a disaster. Even the candidate of the governing party for the next presidential election wants to stay far away from the e-levy, and is, according to what I'm reading, is saying that it will be abolished. It will be abolished, and so on.
If he becomes president.
And the Supreme Court had been pushed into an interlocutory injunction against that Member of Parliament, which meant that that Member of Parliament's constituents did not have the benefit of his presence as a Member of Parliament for several months. The Supreme Court in this particular case is talking about these people and their constituents being deprived of being in Parliament for the remainder of this parliament, which is barely a month or two. The people in South, the people in the South traditional areas, they have not had a representative in parliament the whole of the 8th parliament. And Supreme Court decisions have been involved in making that happen in the way that it has happened. And following the Supreme Court decision, the High Court also recently in whole made a very strange decision. After the Supreme Court says the High Court is a place you go for that, the High Court said it didn't have jurisdiction.
Now that you have mentioned.
So basically, I'm saying to you that, you know, in the end, these things backfire because the kind of political outcome that is being sought. In Honorable Ekp0sě's case, everybody went and campaigned against him, the president, everybody, all the great hierarchy, you know, of the government went to campaign against him. He won by a greater majority. So I'm saying that the people of Ghana, frankly, are also very discerning about what is going on, all these, you know, sometimes machinations, because in the end, when they look at the situation, they end up not really feeling satisfied that what has happened, whether in the court or wherever, is the right thing. And so their voice will ultimately determine.
Okay, we'll come to Saul a little later, but I want us to look at generally the image of the judiciary. There are many people who have accused the NDC of undermining the judiciary. President Addo accuses John Dramani Mahama, AG Godfred Dame, even the immediate past president of the Ghana Bar Association, has said that when the NDC loses a case, then they undermine the image of the judiciary. What do you make of these attacks? Do you think they are warranted?
Well, you know, first of all, I'm not speaking on behalf of the NDC here. I'm speaking as myself.
Yes, I'm talking to you as a professional who has been practicing for years.
Exactly, for many years. So, I mean, I think that it is, you know, really quite naive for anybody to suggest that when you criticize a decision of the court, it is because, you know, or it amounts to undermining the court. You know, I myself, as you recall, have been prosecuted. And when I was prosecuted in 2001, I took the matter to the Supreme Court. The Supreme Court initially gave a decision in my favor. And the Attorney General at that time, who is the president at the moment, said that that decision was a perversion of justice. I mean, I've forgotten all the exact words that he used. But basically, he went on an attack of the Supreme Court. And in the end, the president at that time added to the numbers of the Supreme Court and got a review which then overturned the decision that had been made and so on. Now, when people criticize decisions based on the objective facts, I mean, I've been talking to you, pointing out things that I see as erroneous in the determination of the Supreme Court. I don't think anybody can accuse me of undermining the Supreme Court. I am rather insisting that such discussion should enable the Constitution, the Supreme Court, to uphold the supremacy of the Constitution, to ensure that the Constitution's integrity is maintained. I don't know the specific instances that are being referred to where President Mahama has said something about a decision which is now being said to be undermining or whatever. So I can't get into those. But my point is that just because the NDC or somebody in the NDC criticizes a decision of the Supreme Court should not be taken to mean undermining. Equally, somebody in the NPP, as the Attorney General who was then president, criticizing the Supreme Court at that time, I wasn't about to say that it's undermining the Supreme Court.
Okay. All right. Still on the image of the judiciary, I'm sure that you have seen the recent Mo Ibrahim Foundation assessment, which has dropped, or which says, that assessment says that judiciary impartiality has dropped by 30% from 2017, and that's what we have on the screen now, from 2017 to 2023. And I bring this up because I want to juxtapose it with statements by the National Security Minister, Kandapa, saying that Ghanaians seems to think that decisions are going a certain way by the judiciary. I mean, as a long-standing member of the bar and a practicing lawyer for many years, does this worry you that people actually think this way?
It does. It does worry me. It does worry me hugely for a number of reasons. First of all, maybe a simple, selfish reason. You know, if people lose confidence in the judiciary, it is also a loss of confidence in the legal profession, in my view, because the judiciary consists of people who've come up from the ranks of the legal profession to their exalted positions as judges. And the more confidence is lost in the judiciary, the more confidence is lost in the whole process of adjudication, which is what, we lawyers practice in the court. So I, for even that selfish reason alone, I have a very deep concern. But more seriously, I have a deep concern about the country, particularly as you rightly point out, when you have your national security minister making the observations that he made. And I don't think he made them lightly. I think he made them from a considered, and I believe he was addressing a meeting of judges and being very open and frank with them. And again, let's call a spade a spade. He's the National Security Minister of the NPP government. And what he was pointing out to the judges was that their decisions are seen as favoring the NPP. That's what he was saying. I mean, you put it in very diplomatic terms, but that is exactly what he was saying. And there's been a long pattern as this is concerned. We don't need to go back to the election petition of 2021 and all the unanimous FC decisions and so on. But the reality is that as ordinary citizens make these assertions about the judiciary being just, a unanimous football club or whatever, deciding in favor of one side in what they, try to jokingly see as a football match. I think that we are not far away from seeing a situation where people turn their backs onto the whole judicial process. That is what leads to people taking the law into their own hands and not feeling that they can confidently have justice in court. The Mo Ibrahim Index is not something to be taken lightly. They have for years, that index has for years been studying situations like the judiciary status and so on. They've been studying corruption. And the sad thing is that it's not only the Mo Ibrahim Index that has highlighted some of these issues about the perceptions of the judiciary within the population. You've also had, I think it was a UN study about corruption, in which they were looking at various institutions' corruption, and they were talking about Lands Commission, judiciary, amongst the institutions which are perceived, as being, corrupt in the ways in which they function. Now, I think that we need to be very concerned, especially, like I said, if we are legal professionals, if we are the people in those judicial positions. And we all know, the ANAS investigations and what it led to in terms of, the image of the judiciary. So these issues, and I would dare say there are not just issues about image. There are also issues about the reality. What is the reality? And NAS uncovered certain real accounts of corrupt practice by judges. And as people say, that was only the tip of the iceberg. So we should be concerned enormously, and we should find ways in which to address what is being uncovered through this Mo Ibrahim Index.
Okay, let's talk about 8.1 of the Constitution. Currently,
what does it say?
About the minimum number of judges that we can have at the Supreme Court, which is 9, plus the Chief Justice. The Chief Justice, like many predecessors, have said that there's a caseload at the Supreme Court. And so you have cases like the Domelovo case and that of the COVID restrictions, which they eventually ruled were unconstitutional acts by the president, but there was nothing that could have been done about it because the harm has already been done. Will you support a constitutional amendment to increase the ceiling of the number of Supreme Court judges? Because as it stands, we do not have it.
The Supreme Court at the moment, the constitutional provisions do not provide a ceiling, by the way. There's no ceiling. But
the minimum.
But I want to go back. The Domelevo case, the reason why it wasn't heard early, I don't think it's caseload. It's not a matter of caseload, because there were many other matters that were heard in that time. And if a priority had been placed on that, take this Afenyo Markin's case. Look at the record time in which it was heard, with not even hours. So I think that we must all be clear that these issues about caseload, I see many judges in the court below, the court, like the High Court, also talk about caseload. You go to court as a lawyer in a High Court, you see many, lawyers waiting for their cases to be heard, and often it doesn't get to their turn and so on. If we're going to talk about caseload in the court, we've got to take a comprehensive look within the whole court system. And so I don't frankly appreciate this attempt to, make the caseload of the Supreme Court a thing in itself. If we're going to look at caseload, we've got to look at it in terms of the court system globally, and whether we're going to have 24-hour court sittings like the 24-hour economy, or whatever it's going to ensure that there is more, activity in the courts that meets the caseload. But I don't think that one can separate the matter of the Supreme Court. Now, as far as the numbers of judges in the Supreme Court, again, my view is that the Supreme Court, currently constituted, has probably, I think now about almost 18
judges.
About 18 judges. Now, again, as lawyers, we observe that when the court is sitting, the court doesn't even sit all days of the week. And when the court is sitting, only a certain number of judges are sitting. So many of the 18 are actually not sitting. And it's difficult with that to say that they need an increase in the numbers. I know that the Chief Justice proposed, I think sometime in July, that there should be an increase to 20 from the 15 that was conventionally, But fortunately for us, the Judicial Council took a position against that, because the Judicial Council did not feel that even the timing was right. Because in effect, you would have a situation where an outgoing president is making appointments to the Supreme Court which will put on the Supreme Court judges who will be there until they are 70. And that's being done by an outgoing president. Again, a previous Chief Justice had said, when I think it was President Mahama who had tried to appoint members of the Supreme Court when it was not even yet 15. A previous Chief Justice had said, you know, with this timing, it's getting close to elections, it's better to wait, let the next president come in and make these appointments. But here we have a situation where this Chief Justice, regardless of that previous precedent, was trying to push the Judicial Council into having appointments made. And I say the Chief Justice because she had initiated a memo to the President as far back as in February, in which she was trying to use the caseload justification and so on and so forth. So in the end, the Judicial Council said, no, let's halt. It's close to elections. Let the new president come and consider this. And I think that was the right position that the Judicial Council took. I think it would have looked really, unfair and misused, frankly, of the powers of the president.
So should we put a cap on the number of judges, Supreme Court judges?
I don't think it's necessary to have a formal cap. There are things that people should not require a strict legal sort of instrument or a strict constitutional provision before they go according to them. I think that we sometimes overemphasize what can be achieved through changing the law or reviewing something in the Constitution. Some of the time, the problems we're dealing with are just problems of poor governance by people who have been elected to certain offices or have been appointed to certain offices and who are expected to use their judgment in ways that are beneficial to the national interest. If they don't do that, it's not the law that is at fault. It's not the provisions in the Constitution that are at fault. It is the people. We should hold them accountable. That should be our first point of reference. Of course, there are things that may require modification and so on in the Constitution, and there's been a whole review committee set up, and they've come up with recommendations which, have still not been really looked at closely. But I think sometimes these arguments about Constitution being reviewed and so on, they make us lose sight of the sheer
political highway. Sasu Tsikata ena yetene nkano yabere yabedwafo asese omoje pene kokoti sa odiwi ede emaye aha POG Media so medamase.